In the previous lesson, we asked the question about what it actually is to describe something within equity. What actually is equity itself? And we came up with a number of different definitions, and we talked about the fact that equity was something of a historical development. Well, the historical development that we're going to examine is going to be explored in this lesson. We're going to talk about the history of equity in a relatively brief context. It's going to be as brief as possible, even though, of course, the history of equity and the history of the Court of Chancery is incredibly detailed and complex, but obviously would probably merit its own separate series of lessons. I would just like to add as well, by the way, that the process of researching this lesson and examining some of the historical context was incredibly fun. So I just want to put a little stamp on there about how much fun I had making this lesson. The previous lesson, I said examines the nature of and the definition of the concept of equity. And like I said, we're going to briefly examine the historical development because, of course, it would merit a whole series of lessons itself in order to cover the history of the Court of Chancery in its substantive detail. So, ultimately, we can understand where equity comes from by reference to the kind of legal system and adjudication which existed in the very earliest periods of English history and English law. So the nature of the structure, if you will, of the English legal system from this very, very early period gives rise to the suggestion that equity could be a useful contribution. So the way a claim, for example, would be brought about in this very early period within early medieval England was through a system of writs. Now, a writ is simply a formal order which is issued by some judicial or administrative body, and the system of writs, the royal writ itself, was a system which is limited in the sense that ultimately what you would have to do is bring a claim which corresponded to a particular writ. There were a number of different writs that had authority to remedy, and so as a result of which, if you had a claim that did not correspond to a particular writ, then you wouldn't have a remedy available to you for a particular case. And so as a result of which, the development of the early common law in this regard was particularly rigid and particularly difficult because of the fact that you had a very limited writ system, and then this writ system would actually become even more limited by some historical events which takes place in and around the 1250s. And this includes the provisions of Oxford. So, for those of you who have studied law or history, you'll be familiar with Magna Carta from 1215, but you might not be as familiar with the provisions of Oxford, because the provisions of Oxford were actually quite similar to that of Magna Carta. There were a number of constitutional changes which developed out of the Oxford Parliament of 1258. Now, the reason why I can make the comparison to Magna Carta is because they arose out of a similar kind of dispute. They arose out of a dispute between the king at the time, who was Henry III, and his barons. And what this meant was it acted in a similar way to Magna Carta, which of course was a dispute which gave rise to Magna Carta, which came out of a dispute between the king at the time, which was King John, and his barons. And so as a result of which, the provisions of Oxford did a thing that's useful for us, at least for our understanding, is that it limited the number of writs that can be issued by the king. And this is obviously problematic, owing to the fact that the already rigid system of the common law was beginning to struggle to be applicable in every single case and circumstance that was brought before it. It therefore meant that there would be more rigidity within the common law system, owing to the provisions of Oxford limiting the number of writs which could be issued by the king. Now, as a sort of brief historical aside, it was a symbolic indication that the common law was supreme to the whims of the monarch, so the monarch can just issue a new writ for any circumstance in that regard, but of course that had its own failings in the sense that it made the whole system of legal adjudication particularly rigid. So ultimately, we can see that the provisions of Oxford would be revoked as a result of the Second Barons' War between 1263 and 1267, but the thing that is important for us, again, is that even though the provisions of Oxford would ultimately be revoked when King Henry wins this Second Barons' War, the administrative changes that had been implemented from 1258 would remain pretty much the same, and then would ultimately be confirmed by a further piece of statute, which is the Statute of Marlborough from 1267. So at the end of the Second Barons' War, you get a revocation of the provisions of Oxford, but then you get the administrative changes that were already implemented being solidified by the Statute of Marlborough in 1267, the result of which is ultimately that the issuance of writs became another example of a rigid system of law. So when we have this common law jurisdiction becoming quite rigid and quite difficult to achieve justice in all circumstances and situations, the system of writs begins to show its clear downsides and its clear lack of ability to operate. And this is the sort of groundwork, the foundation, which leads to the establishment of a court of chancery. So in terms of what the Court of Chancery did in terms of legal changes, it did quite little. All it really did was formally establish a permanent place of location for the administration of justice. Because before the Court of Chancery, the king often enjoyed the discretion in the application of law to his subjects. He would often step in and make claims on the basis of justice and the deliverance of justice in a particular case, which ultimately was what the Court of Chancery existed to do. The Court of Chancery was simply the institutionalization of this process. We know that from the reign of King Edward I, that the duty to have this discretion in the administration of justice, in the application of particular cases, would ultimately be given from the king to the king's chancellor. This is owing to the fact that, of course, there were very many cases. The king was a very busy individual, and so as a result of which he would delegate this authority to his chancellor, who then in turn would delegate this authority to his staff and created a fixed court of chancery in this regard, utilizing this kind of administrative authority of the king in the discretion and the application of law, and wielding this power that the king has in the application of justice through not only through the chancellor, but through the staff of the chancellor in the Court of Chancery. Evidence of the Chancellor, for example, of the Chancellor of Edward II, the monarch afterwards, from records of the Parliament of Lincoln in 1315, shows that the Chancellor would even delegate these issues to his personal staff. And this is really where we start to see the formation of a Court of Chancery. It wouldn't be, however, until Edward III that we see the formal fixed location of the Court of Chancery be established at Westminster Hall. Now, the reason for this, the reason for a fixed location of the Court of Chancery, was to firstly show and create the institutionalization of a court of equity, but also it made it easier for the subjects, for the king's subjects, because the Chancellor would historically have to travel around with the king, and so administration of justice meant that you had to go and find where the king was to have a case heard before it. Now you have a fixed Court of Chancery at Westminster Hall. You can go to Westminster Hall and have your case heard in that regard, rather than having to find where the king is. So this is where the Court of Chancery begins, and it stays and remains in Westminster Hall pretty much for the entirety of its period, to the point where it then gets abolished in the 1870s, which we'll get to in a second. But one of the things that's quite interesting here is that it is still something that is considered to have authority that stems from the power of the king. So the reason why we have a Court of Chancery at this point now is because the king would have the discretion historically to get involved in particular cases and to make decisions on the basis of a particular case, to essentially deliver justice for his subjects. This power that came out of the king was only delegated to his chancellor and to the Court of Chancery. So the power of the Court of Chancery still stems at this point from the king and the king's authority. It is only under the reign of Richard II that we start to see the Court of Chancery be understood not necessarily as a power that is deriving out of the king, but as a court that had this power in and of itself and was distinct from the king and the king's administration of justice. So one of the things that the Court of Chancery historically did, at least in the medieval and early modern period, was avoid conflicts which may arise between the common law and the court itself. So it did so by not denying the existence of the authority of the common law, but it rather acted in personam. Rather, it didn't exactly apply legal principles that the common law would apply, like the common law. It instead applied principles of equity to individuals and individual cases. This, of course, can be seen in the concept of the trust, the recognition of the legal owner of a particular property, of a trust being in the hands of the trustee, but of course the transference of legal ownership, where we have the Court of Chancery intervening. Obviously, they impose the importance of obligations in equity for the benefit of third parties. That is the whole nature of the trust solidified in this concept. The idea that you have a settler or a testator who hands this legal rights to a particular trustee, and that trustee holds that property on trust for the equitable fiduciary benefit of the beneficiaries of a trust. And so that's where we get an example of the relationship between law and equity. But the concept of equity in the Court of Chancery was very, very clear in that the applications of principles of equity acted in personam. They were acting on the basis of individual cases, not necessarily acting on the basis of applying law to facts per se. But this is not to suggest that there were never conflicts between the common law and the Chancellor and the Court of Chancery more generally. Under the reign of James I, for example, so we're skipping all the way to the period of 1603 to 1625, there was a conflict between the Lord Chancellor under James I, who was Lord Ellesmere, and Lord Justice Coke. Coke asserted that the Chancellor's issuance of injunctions were considered to be unlawful, and so essentially making the claim that the common law was clashing with the Court of Chancery. The two would attempt to challenge the decisions of each other in a number of different cases. So, for example, in the case of Courtenay and Glanville, they were both overseeing jurisdiction, with the Court of Chancery and Lord Ellesmere dictating that Glanville should be imprisoned, while Lord Justice Coke demanding that Glanville be released. A clear example of a conflict between the common law and the Court of Chancery. A similar thing took place when we look at the Earl of Oxford's case. And so what happened was the Court of Chancery, the Lord Chancellor himself, Lord Ellesmere, would appeal to the monarch to try and resolve this dispute. This dispute was then referred by James I to the Attorney General, who was Francis Bacon, and Francis Bacon favoured Lord Ellesmere's approach, essentially asserting in this regard the authority of the Court of Chancery over the common law, which is quite interesting. And then we can take our time to then come to the fusion of the Court of Chancery and the common law jurisdiction. We're taking a big jump, unfortunately. Like I said, this is a history video, but the history of this particular topic could be a series of lessons in and of itself. If we skip to the Victorian era now, for a start, we can see the popularity of fusing the common law and equity courts coming into fruition. So, for example, the Lord Chancellor, Lord Selsdon, would issue a bill in 1873 called the Supreme Court of Judicature Bill. A number of provisions would be amended as part of this Judicature Act, and it would ultimately become the 1875 Supreme Court of Judicature. At this point, the Court of Chancery ceased to exist. New courts would have been established that have dual jurisdiction, and so then we get the fusion of the two areas of law, to the point now where common law courts, the courts that exist in the judicial system today, the Court of Appeal, etc., 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 could have the ability to apply principles of equity to the concepts that we have here. And so, as a result of which, the debate about fusion is often brought up about whether or not there really truly is a fusion of the common law and the courts of and the law of equity, or rather that they are still separate. You still apply the principles of equity separately to the principles of the common law, but they're just done by the same person. This is a debate that we're not going to have in this series of lessons, but it's a debate that is often had about the fusion of these two areas of adjudication.